So far in this course, we have covered four primary topics. We started by looking at the scope and coverage of UCC Article 2, asking which transactions does Article 2 apply to. Then we moved to questions of mutual assent and contract formation, looking at the similarities and differences between how agreements may be reached under the common law of contracts versus UCC Article 2. We followed up by covering questions of enforceability, by looking at the two defenses to enforceability codified in Article 2, the statute of frauds and the doctrine of unconscionability. And in last week's module, we assumed we had an enforceable agreement and focused on the terms of the resulting contract, looking at the interaction between the express terms of the parties' agreement and terms implied through course of dealing, course of performance, or usage of trade, and the implied duty of good faith, and how contracts may be changed through modification, waiver, or estoppel. In this week's module, we'll continue looking at the terms of a contract by looking at warranties. There are two kinds of warranties in the world, express warranties and implied warranties, and this distinction between the two will serve as our roadmap for this week. But before we look more closely at express warranties, let's start with a more general question: what is a warranty? The right place to start with these types of definitional questions is always the statute, but neither Article 1 nor Article 2 defines for us what a warranty is. Fortunately, warranty has a pretty well understood definition in the common law. A warranty is a contractual promise that certain facts are true. That's it. In the context of a contract for the sale of goods, a warranty is typically a promise by the seller to the buyer about the nature or the quality of the goods being sold. The failure of a warranty, namely, if the facts warranted turn out to be untrue or false, would be a failure of a contractual promise, a breach of contract, giving the buyer, the party to whom the warranty was made, the right to a remedy for breach. You have probably seen warranties in your life before this course. Your car or phone might have come with a warranty against defects for a specified period of time. Indeed, most non-lawyers think of warranties as a promise about how long a good will last or function. But as we will see, the concept of warranty under the UCC is much, much broader than this popular understanding of what a warranty is. Indeed, the UCC's conception of a warranty is broader than what many business lawyers may have in mind. For business lawyers who draft, negotiate, or review contracts for a living, warranties are a ubiquitous feature of the contracts they write and review. Most business lawyers think of a warranty as an express commitment made by a party in the terms of a written contract. Again, we'll see the UCC's concept of a warranty is even broader than this more sophisticated understanding. So what is a warranty under the UCC? Let's start first with express warranties. Express warranties are described in Section 313 of Article 2. This section describes what an express warranty is and how one may be created in a contract for the sale of goods. The first thing to note about this section is that although we are talking about express warranties can be created through conduct. A warranty need not be in writing, and a warranty need not even be made by the seller with an intent of making a contractual promise to the buyer. Instead, Section 313 subsection 1 contemplates that an express warranty may be created in one of three ways. Under subsection 1a, any affirmation of fact or promise made by the seller which relates to the goods and is a basis of the party's bargain creates an express warranty, the warranty being that the goods shall conform to the facts or promises made. Under subsection 1b, any description of the goods provided by seller that becomes a part of the basis of the party's bargain creates an express warranty, the warranty being that the goods shall conform to the description provided by the seller. Comment 1 elaborates on this point, stating that the description need not be in words. Past deliveries by the seller to the buyer may serve as a description of quality, either expressly or impliedly by course of dealings. So a seller can create an express warranty inadvertently through a course of dealings. Finally, subsection 1c says that any sample or model provided to the buyer, which is made a part of the basis of the party's bargain, likewise creates an express warranty. A sample might be a representative example of what the goods will be like. A model might be something that demonstrates the size, shape, or functionality of the goods. In either case, the seller is making an express warranty that the goods shall conform to the sample or model provided. So if the seller does any of these things, it creates an express warranty under 313, a binding contractual promise to the buyer about the facts being warranted. This transformation of the seller's conduct into a binding contractual promise happens through the magic of the UCC. By statute, any of this conduct becomes an enforceable commitment that is made a part of the party's contract that supplements whatever the parties may have expressly agreed to. The fact that a seller's unknowing, informal conduct can create a binding contractual promise is only possible because Section 313 says so. To highlight this point, Note what is not required to create an express warranty. Under subsection 2 of 313, it says that there's no requirement that the seller use the words warranty or guarantee. There's no requirement the seller even intended to make a warranty. So 313 casts a broad net for what could constitute an express warranty. Stated differently, 313 creates a broad source of potential liability for sellers of goods for the benefit of buyers. But there are two important limitations in 313, two limitations of what constitutes an express warranty. The first limitation is one that we've already noted, that in each subpart of subsection 1, an affirmation of fact, description, sample, or model of the goods must be made a part of the basis of the bargain to create an express warranty. This is a point that we'll delve into momentarily. The second limitation is made clear in subsection 2 of 313, that mere puffery does not create an express warranty. By puffery, I mean a statement of value, opinion, or commendation, or praise. A statement that is not about objective fact, not measurable or objectively verifiable, but instead a statement about the value of the goods, or one that merely expresses an opinion about the goods, or a statement of commendation, a statement that praises or recommends the goods. For example, try it, you'll like it, or this suit looks great on you. Those are all statements of puffery. They do not give rise to warranty liability. The rationale is that sellers are expected to make favorable comments about the goods they're selling, and a reasonable person in the buyer's position would not rely on such puffery. Sometimes it's very, very easy to spot puffery. Imagine, for example, I'm trying to sell you my old car. It looks pretty beat up from the outside, so to pique your interest, I tell you, don't worry, it looks great on the inside. That's clearly my subjective opinion or commendation about the car. Looks great is not something that is measurable or objectively verifiable. The statement is simply too vague, too indefinite. Indeed, the more vague or indefinite a statement is, the less reasonable it would be to rely upon it as a buyer. And the less reasonable it is to rely upon it, the less likely it is that the statement is to serve as a basis of the bargain. So in this context, the puffery limitation is just another expression of the basis of the bargain test that we will consider momentarily. Sometimes, however, it is more difficult to distinguish puffery from statements of fact. Imagine the same scenario, but this time, to pique your interest, I assure you, this car gets great gas mileage. This statement is a bit more definite and specific. What is excellent is the car's fuel mileage. This sounds more like an express warranty. To be sure, excellent is clearly an opinion, but all opinions are based on some underlying facts. All opinions implicitly assert certain underlying facts to be true. In this case, the fact is that the fuel mileage of this specific car compares favorably to other cars, or perhaps other cars like this one, and that fact could be objectively verified. When it is not clear-cut whether something is mere puffery or express warranty, there are a variety of factors that courts might look at to make the distinction. What all of these factors point to, though, essentially, is the same question: whether it was reasonable for the buyer to rely on what the seller asserted, that the seller has some specialized knowledge or information that the buyer is unlikely to have or have access to, knowledge or information that could reasonably cause the buyer to rely on the seller's assertion. Coming back to my example, if I'm trying to sell you my car and I'm not a law professor but a merchant of cars, then you might reasonably expect that I have special knowledge or skill about cars and fuel mileage. So my statement about fuel mileage is more likely to be an express warranty than if I am merely a law professor trying to sell his old car. But the upshot of this is that it's not always easy to distinguish between express warranties and mere puffery. So the analytical framework for express warranties that we've covered so far has two steps. The first step is to ask, did the seller make any affirmation or promise regarding the goods or provide a description, sample, or model of the goods? If the answer is no, then there is no express warranty. If the answer is yes, however, we have to move on to the second step and analyze the limitations on express warranties. In this second step, we must ask, were the statements the seller made mere puffery, merely an expression of value, opinion, or praise? If the answer is yes, then there was no express warranty. But if the answer is no, then there is a third inquiry we must make in the express warranty analysis. We must ask, did the statement become part of the basis of the bargain? Which brings us to the basis of the bargain requirement, the second limitation on what constitutes an express warranty. Even if a statement, description, or sample of the goods is not mere puffery, it does not create an express warranty unless the statement becomes a part of the basis of the bargain. This is required by each of subsection A through C in section 313 subsection 1. But what does the basis of the bargain mean? Unfortunately, courts disagree, with the case law offering three distinct approaches. The most restrictive approach requires the buyer to show that the buyer actually relied on the seller's promise affirmation description sample or model. Stated differently, there must be some causal relationship between the alleged warranty the seller made and the buyer's decision to assent to the deal. The alleged warranty need not be the only reason, but it must be one that substantially contributed to the buyer's decision to assent. Under a second approach, the buyer enjoys a rebuttable presumption of reliance on the seller's alleged warranty. The buyer need not provide evidence that the seller's promise affirmation description sample or model induced the buyer to assent, but the seller can adduce evidence to rebut that presumption, that the buyer perhaps didn't care about the facts being warranted, or perhaps the buyer knew that the facts being warranted were utterly untrue. This approach is supported by comment 3 to section 1.3, which provides that in actual practice, affirmations of fact made by the seller about the goods during a bargain are regarded as part of the description of those goods. Hence, no particular reliance on such statements need to be shown in order to weave them into the fabric of the agreement. Rather, any fact which is to take such affirmations once made out of the agreement requires clear affirmative proof. By implication, that proof must be provided by the seller. Under the least restrictive approach, the basis of the bargain requirement does not require the buyer's reliance at all. Any facts asserted by seller before or at the time of formation are a basis of the bargain. This essentially creates an irrebuttable presumption of reliance by the buyer as long as the buyer is aware of the seller's assertions. So under any of these three approaches, at minimum, the buyer must be aware of the seller's assertions. But what more does the basis of the bargain requirement mean? In Rogath versus Siebenman, the court seems to adopt some version of the second approach. This is a well-known case in which Siebenman sold a painting purported to be a self-portrait by the 20th century Irish painter Francis Bacon to a buyer, Rogath. Siebenman made an express statement about the painting's authenticity in the parties' written contract. Indeed, the contract even used the word warrant. But of course, for something to be a warranty under the UCC Article 2, it must also be a basis of the bargain. Siebenman says that at the time the contract was made, Rogath was fully aware of the truth, that there were questions about the authenticity of this painting, because Siebenman personally told Rogath about those issues. So according to Siebenman, it was impossible for Rogath to be relying on Siebenman's assertion of authenticity in the written agreement. It could not have been a basis of the bargain. The legal issue presented to the court is whether the statements that a buyer doubts are true can still become a part of the basis of the bargain. Stated differently, can a buyer rely on statements that she believes to be false? The court held that the critical question is not whether the buyer believed in the truth of the warranted information, but whether the buyer believed he was purchasing the seller's promise as to its truth. What the buyer must be relying upon is not the truth of the seller's assertion. Instead, what the buyer must be relying upon is the seller's willingness to provide the warranty, to make the legal commitment that if the assertion turned out to be untrue, the seller would be liable to the buyer. So according to this court, the basis of the bargain does not mean that the buyer must actually believe in or rely upon the accuracy of the seller's statement. Instead, the buyer must simply rely on the seller's willingness to stand behind that statement, the seller's willingness to be liable for damages if the statement is untrue. So that question in turn depends not on what the buyer knows for himself, but on what the seller actually told the buyer about the painting. Because if the seller told the buyer that the painting may be a forgery, then the buyer cannot claim that the seller's assertions to the contrary, namely that the painting was an original, was a basis of the bargain. Both things cannot be true. But if the buyer knew from other sources, that is, sources other than the seller, that the painting may be a forgery, then the seller's warranty might still be a basis of the bargain, because the buyer was not relying upon the truth of the seller's warranty, but upon the seller's willingness to stand behind the facts covered by seller's warranty. So ultimately, the court denies summary judgment. There's a factual issue of exactly what the seller told the buyer before agreeing to the express statement that was made in the written contract between the parties. The court thus leaves open the possibility that a buyer who doubts the truth of the warranty is actually buying the seller's willingness to pay. The court justifies this conclusion by comparing the seller's statement to insurance. Though doubted by the buyer, the seller's statement could still be part of the basis of the bargain because the buyer was relying on it as a form of insurance. If the statement was untrue, the buyer would have recourse to compensation from the seller for breach of warranty. Note here that the issue in Rogath is one the parties could have contractually resolved ex ante, which highlights the value of transactional lawyering, to anticipate, address, and thus avoid disputes that might later arise. As the court notes, the buyer may preserve his right by expressly stating that disputes regarding the accuracy of the seller's warranties are unresolved and that by signing the agreement, the buyer does not waive any rights to enforce the terms of the agreement. Stated differently, Rogath, the buyer, could have included what is sometimes called a sandbagging clause in the parties' agreement. Here's an example of a sandbagging clause. Take a moment to read it. This clause makes it clear that the seller's warranty is a basis of the bargain, regardless of the buyer's knowledge as to its accuracy or inaccuracy. Had the parties included this clause in their written contract, then there would have been little question that the seller's warranty as to the authenticity of the painting was a basis of the bargain, regardless of what else the seller may have actually told the buyer. Alternatively, Zieberman could have included what's called an anti-sandbagging clause in the parties' written contract. Here's an example of an anti-sandbagging clause. Take a moment to read it. As the name implies, this clause has the opposite effect. It makes it clear that the seller's warranty is not a basis for liability if the buyer knows the warranty is false or inaccurate. So in this video, we covered express warranties under Article 2, Section 313. In particular, we covered what is a warranty and what does or does not qualify as an express warranty under Section 313. In the next two videos, we'll look at a different kind of warranty, one that is not based on the parties' express words or conduct, but rather is implied into the parties' contract strictly as a matter of law.